Good evening, everyone. I'm Harshita Yes, a student of University Law College, Bangalore University, and it's my immense pleasure to be the master of ceremony for this session. At the outset, I would like to extend my humble salutations to our distinguished guests, faculty members of University Law College and Department of Studies in Law, and greetings to all the participants who have virtually gathered here today. After hosting a series of successful lectures, ULC is now glad to host a 17th lecture of the ULC Special Lecture Series, which was started with the intention to hear and interact with the various advocates and legal luminaries. With the support and guidance of our Honorable Vice Chancellor, Professor Dr. K. R. Venugopal, and keen initiation of the principal and faculties of University Law College, Bangalore University. The first lecture was inaugurated by Honorable Shri Santosh Hegde Sir. And today, it's indeed a privilege to have with us Shri Santosh Paul, Senior Advocate, Supreme Court of India. Now I request our beloved Principal, University Law College, Bangalore University, Professor Dr. Sureshri Nadigowda to render the welcome address.
Okay, thank you, Arshita. Good evening, everyone. Respected guest speaker of the day, Sri Santosh Paul Ji, Honorable Vice Chancellor, Bangalore University, who is patron of the program, esteemed colleagues, invitees, principals of various law colleges, and dear students. Indeed, we are very happy and privileged to have today with us Sri Santosh Paul Ji, who is a senior advocate practicing at the High Court and Supreme Court of India. And he is an eminent advocate and a scholar who has authored several books and also published many articles, scholarly articles in law journals. And in fact, we are very happy that Sri Paul Ji has kindly consented to interact with us and address us. And at this juncture, I would like to make a special mention that Sri Mohan Katarki, the Senior Advocate, Supreme Court of India, who is a great well-wisher of our University Law College, has in fact suggested us to invite Sri Santosh Paul Ji, considering his area of interest and also his expertise in the area of judicial appointment related aspects. And as a result, Sri Santosh Paul Ji is here with us to address us on the National Judicial Appointment Commission judgment. And I, on behalf of University Law College and all the concerned, I extend you a very warm welcome to this special lecture series, sir.
Thank you, sir. Thank you for extending a warm welcome.
I also, wait, I have to welcome others also. In fact, our Honorable Vice Chancellor may be gracing the occasion little late as he is head up with some important meeting. I also welcome him in his absence. And we have with us our esteemed colleagues, Professor Dr. V. Sudesh, former principal, Dr. N. Dashrath, Chairman and Dean Faculty of Law, Dr. N. Satish Gowda, Faculty, Dr. Jyoti Vishwanath, Dr. Chandrakanti, and I extend them all a warm welcome to program. And we have our President of the Alumni Association and other members of the esteemed Alumni Association of University Law College, and many principals and faculty members who have joined from different parts of the state and even outside the state. I extend them all a very warm welcome. And finally, I welcome all our students for this program. Thank you very much.
Sorry for the interruption, sir.
And in fact, I am sorry. I think Sabina Paul Madam has also joined. I also take this opportunity to extend you a very warm welcome to the program, Madam. Thank you.
With my apologies for interrupting, and thank you very much for extending a warm welcome to our guests and the participants for today, sir. Thank you so much. Before we begin, any questions on the lecture can be posted to Hitake, co-host, and the YouTube viewers can post their questions in the comment section. We will take it up in the question answer segment. As we all know, today's lecture is on the topic Critical Analysis of NJAC Judgment 2015. Now I take this proud privilege to introduce the esteemed dignitary for today's lecture, Shri Santosh Paul. Sri Santosh Paul, senior advocate at Supreme Court of India, has been practicing for 28 years. He has pursued BA Economics major from Atherton College, Mumbai, and LLB from Government Law College, Mumbai. He has obtained second rank in the Advocate on Record exam in the year 1995. He joined the chamber of C.V. Francis Advocate, practicing on the original side of the Honorable Delhi Court from 1988 to 1993. During this apprenticeship, he practiced in the Supreme Court, Delhi High Court, Company Law Board, and Central Excise and Gold Control Tribunal, and the Monopolies and Restrictive Trade Practices Commission. He started his independent practice in 1993. He has appeared as the advocate on the record in the landmark case of the NJAC and in the case which decided to transfer the cases from Jammu and Kashmir to other states in Anuta Kushwaha versus Pushap Sudan. So his famous books include Appointing Our Judges, Forging Independence and Accountability, Essays on Judicial Appointments, and Analysis of the NJAC Judgment, and Choosing Hammurabi, Debates on the Judicial Appointments, which is also prescribed as course materials in the Nalsat and in other various universities. His zeal, knowledge, and his contributions to the legal fraternity is an inspiration to the youth. I request Sri Santosh Paul, Senior Advocate, Supreme Court of India, to present his analysis on the NJAC judgment 2015. Sir, we are eager to hear from you. I would request you to kindly take over.
Distinguished Professor Suresh, distinguished Professor D.N. Dashrath, members of the Dr. Satish Gowda, members of the faculty, my dear students, and distinguished guests. Though I have authored 2 books on this subject, it's about 5 to 6 years now, ever since these books were published and the judgments came out. There is a constant state of flux as to how judges should be appointed, what should be the criteria, how we should go about it. These have remained to a great extent unresolved ever since the making of the Constitution. As students, you are very much aware of the 2 provisions in the Constitution which govern appointment of judges. The first one being Section 124, which deals with the appointing of judges of the Supreme Court, and 217, which deals with the appointing of judges of the High Court. Now here, there is something which has vexed, and I'm telling it is vexed because it has caused an enormous amount of debate. It has caused an enormous amount of consternation. It has caused an enormous amount of rancor, despite a clear provision of the Constitution in existence, primarily because facts and circumstances change over the years. When the Constitution was being debated, there was this provision which was sought to be inserted, and I will just quote it. The appointment of Supreme Court judges shall be after consultation of such judges of the Supreme Court and the High Courts. So the President is to appoint on the consultation with such judges of the Supreme Court after Supreme Court and the High Courts, and consult the Chief Justice of India. Now, the expression used is consultation. And a similar provision is 217, which deals with the High Court. Again, it shall be in consultation with the Chief Justice of India, the Governor of the state, and the Chief Justice of the High Court. Now, what is consultation becomes a controversial debate which continues even till this date. We have not been able to resolve it. There are judgments have come, but there is no uniform consensus. Though there is a judicial verdict of the NJAC, even today, what would constitute consultation is still a concept in a state of flux. So when I was asked to talk about the critical analysis of NJAC, it became necessary to put into context the historical backdrop of what happened. And the historical backdrop of essentially 5 decisions. The first decision is the SP Gupta. The second decision is what is called the second judge's case, the Supreme Court Advocates on Record of 1993. The third was the Special Reference 1, which came in 1998. In fact, it is 1997. It features in the 1998 SEC. Then came a very unsatisfactory situation, and then came the NJAC. And prior to the second judge's case after SP Gupta, because of political appointments, a decision which is largely ignored in the academia was Subhash Sharma's case. I will dwell very briefly into it. But it is, as I said, you will have to understand the context in which this debate has been going on. The conflicts which have happened between the legislature, the judiciary, and the executive, which has also largely shaped the question of appointments of judges. And I would like to briefly touch as to how judges are appointed in the United Kingdom, how judges are appointed in America. Even here, you will find that there is very little consensus as to how they have to be appointed. What are the criteria to be appointed is very, very divergent. Though everybody says the ultimate aim and object of appointment of judges is the independence of the judiciary. But as I will demonstrate to you, what constitutes independence, how it can be achieved, is not a settled proposition even today. Now, when this clause came to be introduced in the Constituent Assembly, the question arose, consultation with the Chief Justice, does it constitute concurrence, or is it mere consultation? Because ultimately it is the President of India who has to appoint. So here we have Dr. Ambedkar. I don't know, I had given a kind of a screen share. If somebody is in charge of the screen share, can you just put up?
Yes,
one?
sir, it can be shared, sir. Yeah.
Yes. Now, Dr. Ambedkar was very clear about it. If you can just push it to the left, I mean, it all depends on, I guess. Yes. Now, Dr. Ambedkar was very clear that the Chief Justice will be involved in a consultative process. He will not be the vetoing person with a veto power. So therefore, if you see, what Dr. Ambedkar said is the draft article therefore steers a middle course. It does not make the President the supreme and the absolute authority in the matter of making appointments. It does not also import the influence of the legislature. The provision in the article is that there should be a consultation of persons who are ex hypothesis well qualified to give proper advice in matters of this sort. And in my judgment is that this sort of provision may be regarded as sufficient for the moment. Now, he is also quite aware that in due course, historically, there will be changes which will take place. He said, for this moment, this is good enough. There are certain high functionaries who have to be consulted, and it is on the basis of that advice that the president will appoint. Then there is I will tell you to change when you need to. The conflict between the legislature and the court almost instantly cropped up immediately after the independence, and the bone of contention was the Land Reforms Acts. As you know, we were under a oppressive land reform, land laws of that time. There were the zamindaris and the jagirdaris, and large swaths of the population were deprived of land. It was part of the Congress manifesto that when they come to power after independence, they will bring in land reforms so that there is land redistribution across the country. Now, as soon as the land reforms laws began to be implemented, enacted and implemented to be more precise, the first of the decisions which came was the striking down of the Land Reforms Act by the Patna High Court. This was followed by two significant decisions. Was West Bengal, state of West Bengal versus Bela Banerjee, and Dwarka Das Srinivas versus Solapur Spinning and Weaving. What happened here is, what they said was, the court said is, you have to give the compensation which will be paid for this will be the market price of the land. Now, this would jeopardize the entire land reform legislation in the country. The judgments had to be reversed by legislation, and therefore the fourth constitutional amendment came in place. They said it will be just compensation. It cannot be the market price. And so the entire battle moved between, I will have to do one small thing, you know, just bear with me. Just connect it on this because this is unstable. This conflict between the right to property and the reform legislations were a constant source of conflict between the legislature, the parliament, and the courts. In 1967 came a very critical judgment of Golaknath versus State of Punjab, which all the students of constitutional studies will be aware of, where they said you cannot amend the fundamental rights. This was quickly followed by two significant decisions. Yes. This was followed by two significant decisions. One was the bank nationalization case, when the private banks were nationalized and the constitutional validity of the nationalization was challenged in the Supreme Court. It was struck down. This was followed by what was popularly called as Privy Purse case, which is actually Madhav Rao Scindia versus Union of India, where privy purses promised at the time of independence to erstwhile rulers of India was sought to be taken back. And this was also struck down. What followed was, in 1971, immediately after the Privy Purse decision, Mrs. Indira Gandhi took the conflict which is happening in the courts into the political arena. She their elections to the parliament. And these two decisions became the subject matter of the elections of 1971. And she came back with a thumping majority because the people of this country were trying to get rid of feudal systems in place by way of reformative legislations. Once she came back, there have been an accusation that the appointments of judges are not exactly in tune with the aims and objects of the Constitution. The appointments, in some manner, are political in nature, and therefore, a case came about which is called the first judges case, which is the S.P. Gupta versus Union of India. Some of the judges who were appointed at that point of time, they were not confirmed, and it ultimately wound its way to the Supreme Court. The critical question now came: who appoints the judge? Whose voice gains primacy when it comes to appointing a judge? Is it the government's voice, or is it the voice of the Chief Justice? So in S.P. Gupta, a very erudite judgment was written, and the dominant opinion was the primacy lay with the government. Can you just screen share? What was laid down here? Yeah, you can just come down. Justice Bhagwati articulated this proposition very lucidly. So here he says, so also where a judge of the Supreme Court, they talk about judges of the High Court being appointed, and here he says, so also where a judge of the Supreme Court is to be appointed, the Chief Justice of India is required to be consulted. But again, it is not concurrence, but only consultation. And the central government is not bound to act in accordance with the opinion of the Chief Justice of India. The ultimate power of appointment rests with the central government, and that is in accord with the constitutional practice prevailing in all democratic countries. And to a large extent, this is true even today when it comes to other jurisdictions, and I will tell why we had to deviate from it. So the voice of the Justice of India is only to the extent of a consultation. What will prevail is the decision of the government. So the primacy is with the government and not with the Chief Justice. So the word consultation can not be read as concurrence. It has to be consultation as the dictionary defines it. This was followed by a spate of appointments. There is a lot of history to it, which I have authored in my books. There were a lot of issues which cropped up, and one of the issues which are cropping up is judges are not independent. Judges are somehow those who are appointed who are in favor of the government or who find favor with the government. In this scenario, the decision of S.P. Gupta was 1982. Almost a decade went by, and it was felt that the appointment system is not satisfactory. Independence of judges is not being adhered to. It was in this context that one of the lawyers, a very eminent lawyer in Supreme Court, Subhash Sharma, filed a petition. And in that, the first of the issue of reopening of S.P. Gupta once again came about. And this was decided by three judges, Ranganath Mishra, Justice M.N. Venkatchalaya, one of your alumni, and Justice M.M. Kunchi. Now, I'll just tell what they said. If you can just come down a little bit in item number 3. I'll just read it. It has been increasingly felt over decades that there has been an anxiety on the part of the government of the day to assert its choice in ultimate selection of judges. If the power to recommend was to vest in the state government or even the central government, the picture is likely to be black and the process of selection ultimately may turn out to be difficult. To say that the power to appoint solely vests in the executive, and that the executive, after bestowing such consideration on the result of consultation with the judicial organ of the state, would be at liberty to take such decision as it may think fit in matters of appointments, is an oversimplification of a sensitive and subtle constitutional sentence, and if allowed full play, would be, there is this of the doctrine of judicial independence. So they felt this interpretation in S.P. Gupta is not correct, to say the government will have the final say in appointing judges. It is in this context that the second judge's case, which is popularly called as Skora versus Union of India, comes into being. This decision comes about in 1990, 93. Here, the judges now come to the conclusion, they say consultation in Article 124 and Article 217 is not mere consultation. It requires the concurrence of the Chief Justice. Now, here they were a little careful because Dr. Ambedkar had something very important to tell the court, to tell the Constituent Assembly, because he was not ready to give that power of appointment, that power to veto to the Chief Justice of India, because he felt, as far as the Chief Justice is concerned, he is also any other human being. He's capable of everything which any human being would face with. So he said, I'll just read out, with regard to the question of concurrence of Chief Justice, it seems to me that those who advocate the proposition seem to rely implicitly both on the impartiality of the Chief Justice and the soundness of his judgment. I personally feel no doubt that the Chief Justice is a very eminent person. But after all, Chief Justice is a man with all the failings, all the sentiments, all the prejudices which we as common people have. And I think to allow the Chief Justice to practically veto upon the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government of the day. I therefore think that this is a dangerous proposition. So there is this stinging warning of Ambedkar in the Constituent Assembly that you cannot give a veto power to the Chief Justice. So what was done in Skora was, when you say the opinion of the Chief Justice, you will have to get his concurrence. It means not the Chief Justice alone. It will include 2 more senior judges of the Supreme Court. So it is not one individual, but there are 3 individuals, and they have to take his wishes into account. This judgment, again, in a span of 3 years, again comes into question. And what is called the third judge's case, which is called the special reference number 1, comes into being. In special reference 1, what the Supreme Court says is it's not enough for 3. Let there be 5 judges. So the collegium of judges, that is 5 senior most judges of the Supreme Court, will determine appointments. That is 1998. Now, what happens here is the power of the executive to appoint judges somehow went straight to the collegium of judges. It ran to a great extent fairly smoothly, fairly satisfactorily. And we saw some very good jurisprudence, and we also found that the judiciary was extremely independent. In fact, it even finds mention in Amartya Sen's book, A Quest for Justice, as to how he views the Indian Supreme Court, because it enters into areas like the mining mafia, the coal gate, and every other sphere, and the independence with which the Supreme Court was moving was something considered remarkable. But there was a severe shortcoming in this. The shortcoming here was the appointments became from a very close circle of lawyers. It was found that you were somehow, there were a lot of statistics which showed that you had to be connected to a judge's chamber, or you were a judge's relative, or you were in some manner connected with the judge, and then only your chances of appointment happens. So this came under severe criticism. And the UPA government had brought in the NJAC. By that time, the government went away. That was the second term of UPA, and then came the NDA government, and immediately they brought in the NJAC Act and the Constitution 99th Amendment Act. Here, the problem was the Constitution 99th Amendment Act and the NJAC Act was supposed to be a replica of what happened in the United Kingdom. In the United Kingdom, there is what is called the Judicial Appointments Commission. Now, I have written an article on this. It is there in my book. This came about because they were also faced with a very similar situation, but their situation was slightly different because it was the law minister who appoints judges. One of the singularly dissatisfactory periods of appointment was of Lord Halsbury. Lord Halsbury appointed because he served as its law minister, what they call the chancellor. He served as its law minister for 17 long years. And his appointments were so terrible that it came under severe criticism. And I will indicate how this system was castigated by the media in England. And ultimately, it was Tony Blair who had to set aside this system of appointments by what is called the Constitution Reforms Act of 2005. Now, this is what R.F.V. Houston, your libraries will contain, he's a jurist, comment on Lord Halsbury's appointments. He said, Halsbury appointed to the High Court and to a lesser extent to the County Court men of little or no legal learning, whose previous career in public life had been largely in the service of the Conservative Party, or else were relations of his own. It's a very damning statement of one of the longest serving law ministers of UK. And it is this feeling that here is a very small coterie from which of talent pool where the judges are being appointed. In fact, they found almost 90% of the judges come from two universities in UK, Cambridge and Oxford. So the question came, when the Labour Party came to power, how is it that only two universities in this country can produce this? How come none of the other 100-odd universities are able to produce any judges? So this became a bone of contention, and Tony Blair's government brought in the 2005 Constitution Reforms Act. Now here, there is something very, very important, which is why, I was one of the persons who challenged this act, NJAC Act, as well as the 99th Amendment, which is called the NJAC case, I was personally against it for a certain view, because if there was honesty of purpose, then you would have had to follow what the UK Parliament did under the Judicial Appointments Commission. And I'll tell you what the UK did. And it is very important, because what they did was the Judicial Appointments Commission was constituted. So the power of the law minister to make appointments, it went out of his hands and goes into a body called the Judicial Appointments Commission. Now, the Judicial Appointments Commission has no political component. There was a judge of the UK Supreme Court, a judge of the UK High Court, one judge of the Court of Appeals, and two other judges who were in that hierarchy. It is not that only Supreme Court judges are going to be there in that committee, but that commission would have 5 different judges who are in different levels of the hierarchy of courts. Now here, one very important and very significant aspect was that the president of the Judicial Appointments Commission is not a judge. It's a lay person. And the first judicial appointments of commissioner of UK was a person of Indian origin called Baroness Usha Prasher, who held the position for a good 5 years and who happened to come to India also. And she explained how they eliminated the political component out of the judicial appointment system. What happened in NJAC Act and the 99th Amendment was something very drastically very different. What was done is they said, here is a 6-member commission, 3 senior most judges of the Supreme Court, 1 law minister, and 2 eminent persons. So eminent persons becomes a political component along with the law minister. And here there is a judicial 3 judges. And 2 persons had the right to veto an appointment. So either the judicial component or the political component could, if there were 2 people, they could veto an appointment. This was not an attempt at judicial independence. It was an attempt to somehow come a challenge was mounted, and ultimately the NJAC Act came in. Now, you may quite be curious, because in every part of the world, it is the government which appoints, and UK was the exception. There is a historical origin, which even in the NJAC they do not write, but it was Harold Lasky, one of the greatest political scientists of his time, who was the chairman of the Labour Party in UK, who wrote in that seminal work called The Grammar of Politics, because he saw the appointments made by Lord Halsbury, how he had put his own people, who had put political people as judges. And therefore, he had recommended that when you constitute an appointments body for judges, it should consist of judges, because they will be able to determine who is best suited. Of course, he did not contemplate the situation which we faced after the second judge's case, which is the judges appointing was from a narrow pool of lawyers. And that was probably not contemplated, but the genesis of this thought was in the Grammar of Politics. Anyway, after the NJAC was brought into force, we challenged it. It was hurriedly notified. When we challenged it, it was hurriedly notified. Ultimately, it was struck down. And it has been struck down for various reasons. And one of them is to bring back the political component, which they said would seriously compromise the independence of the judiciary. So It is in this backdrop that the NJSC judgment comes into being. So during the arguments, a very forceful argument was made that you cannot eliminate the government from the appointments process. It never happens anywhere, which is not correct, because the Judicial Appointments Commission of UK was the stellar example of eliminating the political component. This was followed in South Africa. It has been followed in Canada, to the best of my knowledge. I do not know how it is functioning in Australia, but it is working fairly well in these three countries, that is Canada, UK, and South Africa. Now, the point which was being forcefully argued was, look at the American system. The politicians appoint judges. What's wrong with that? In fact, everything is wrong with that. As you know, as the crisis is looming large in the election which has just taken place in United States, the attempt of the president is to somehow bring it before the Supreme Court, mount the challenge to the election process in the Supreme Court of United States. Why? Because 6 out of 9 judges are appointed by his political party. And there is little faith in amongst the American public when it comes to the US Supreme Court. You can almost predict with certainty, if it is an issue of abortion, you know that the Republican appointed judges will vote in this way and the Democrat appointed judges will vote in this way. So it is a clear-cut political body, and which is what the president is now trying to do. So to say that this is the ideal system was not correct. We challenged it and the court accepted that point. Now, I will just give you an example. When Justice Rehnquist, he was appointed and he reigned as a Supreme Court Chief Justice for, I think, about 6.5 years. He was a Republican appointed judge. I think President Nixon appointed him. Now he says something very telling. He says, why should the politician appoint a judge? Now his argument is, politician is elected. So the politician wishes that, a person of a judge should have a particular viewpoint, because that way he is carrying the mandate of the people to the court. And I will just read out what he says. When a vacancy occurs on the court, it is entirely appropriate that vacancy should be filled by the president, responsible to a national constituency, as advised by the Senate, whose members are responsible to the regional constituencies. Thus, public opinion has some say in who shall become judges of the Supreme Court. There is an inherent fallacy in this argument. And this argument was addressed in the NJSC judgment. The fallacy is, let us take Government A appointed Judge X. Judge has the views of that Government A, that political party. After 4 years, another Government B comes into play through the election mechanism. Does that judge who is appointed, and in the case of the United States, it's an appointment for life. There is no retirement. It is for the judge either to pass away or retire himself, whatever he chooses. If Government B comes, will the Judge X who was appointed by Government A carry on the philosophy of Government B, or will he carry on the philosophy of the Government A? There is an inherent flaw in that process. And which is why, by having appointed 6 judges, you have now taken control of a court of 9. And they will forever act in a particular manner. So this argument was rejected by Justice Kehar, who said, we do not have a political spoil system. Our system has to be politically neutral. That was rejected. The question of the two eminent, the next question was with the two eminent judges, two eminent persons who are appointed under the NJSC. Since I was there during the hearing, the judges repeatedly asked the question, who, according to you, are the two eminent persons who you will appoint? You will not believe what was the answer. One was Satyajit Ray will be, at that point of time, Mr. Satyajit Ray, that eminent filmmaker was alive. He said he'll be one of the eminent persons. And who will be the other? It'll be somebody like Bill Gates. Now, if you look at that argument, it holds no water. Firstly, I do not think Satyajit Ray would want to spend his time in appointing judges in this country. Number two, a Bill Gates or his equivalent in India will have hundreds of cases all over the country. And how is it that he will have a say in the appointment of judges? So this argument was rejected. They said this eminent person concept does not hold any water and has to be set aside. And the second aspect was, should the law minister be there? Should he have a power of veto? Should he have a say in the matter? Now, the point was, the law minister, according to the NJSC, which is endorsing the Skora judgment of 1993, they said, see, you're already there. You have your role to play. You give the inputs. And we will consider those inputs. And ultimately, it will be the primacy of the Chief Justice as reflected in along with his four senior most judges, who will determine who will be appointed as judges. So that argument was also rejected. And as I said, the spoil system is a political party comes into power, and then all the appointments are the political party's wishes. That system does not exist in India, and it will be deleterious to have constitutional functionaries appointed on that basis. Therefore, that was also rejected. So what was ultimately decided was this entire process of bringing in a political component into the appointment system was completely rejected. And what was kept in place was once again the Skora, that is the Judges Case 2 and Judges Case 3, that is Skora and Special Reference 1. Now, as far as removing why the Union Minister should not be a critical component of the Judicial Appointments Commission, this is what I think this is Justice Kehar. In the NJSC, the Union Minister in charge of law and justice would be a party to all selections and appointments of judges to the higher judiciary. It may be difficult for judges approved by NJSC to resist a plea of conflict of interest, where the political executive is a party to the list. The above would have the inevitable effect of undermining the independence of judiciary, even where such a plea is repulsed. Therefore, the role assigned to the political executive can at best be limited to a collaborative participation, excluding any role in the final determination. So final determination continues to be with the collegium. This is in long and short the history of how the judicial appointments was viewed over the years, starting from the Constituent Assembly till the 2005 judgment of NJSC. Before I part with, I would like to, bring to the attention two telling quotations. One is by this eminent American journalist called H.L. Mencken. Can you just bring to Romans 7? Yes. H.L. Mencken was one of the very dominant American journalists of his time, who wrote extensively on the Constitution as well. He said this something very telling. But when politicians talk thus, or act thus without talking, it is precisely the time to watch them most carefully. Their usual plan is to invade the Constitution stealthily and then wait to see what happens. If nothing happens, they go on more boldly. If there is a protest, they reply hotly that the Constitution is worn out and absurd, and that progress is impossible under the dead hand. This is the time to watch them especially. They are up to no good to anyone save themselves. They are trying to whittle away the common rights of the rest of us. Their one and only object, now and always, is to get more power into their hands, that it may be used freely for their advantage and the damage to everyone else. Beware of all politicians at all times, but beware of them most sharply when they talk of reforming and improving the Constitution. There is another quote, and this is by one of the boldest judges that I have read about. This is the quotation by Justice Dorab Patel. Justice Dorab Patel, for this generation of law graduates, would be today something which nobody will know of. You know, when in 77, an elected government in Pakistan was overthrown by the military coup by a general named Zia-ul Haq. Zia-ul Haq came to power and appointed his very good friend, who was not a lawyer, as the Chief Justice of Pakistan. A court in Karachi, the High Court of Karachi, granted Bhutto bail because he was accused of in a murder case. The Chief Justice was removed, another Chief Justice was brought in, and a trial took place, it was a sham by any standards. He was sentenced to hang. The matter came before the Supreme Court of Pakistan. This Supreme Court of Pakistan by then had become subservient to the general. And the one man who dissented from the judgment, who refused to hang Bhutto, was Justice Dorab Patel. And this is what he said: the struggle for independence of the judiciary has therefore become a part of the struggle for rebuilding tolerant societies in South Asia. Societies which respect human rights, and especially the individual's right of dissent. In the long run, an independent judiciary can survive only in a free society. Therefore, we have a long and difficult struggle before us. I hope we will have the courage and the perseverance to carry on this struggle. This was Justice Dorab Patel. There is an interesting episode. After he delivered the judgment, one day he was a very good friend of Mr. Fali Nariman, and Mr. Nariman had this story to tell all the time. He said after he delivered the judgment, one day he found a barrage of military vehicles entering his residential compound. And lo behold, it was none other than Justice Zia-ul Haq himself. And obviously he was frightened because he has written a dissenting judgment, refusing to hang his political opponent. And Justice Zia-ul Haq came to his house and treated him extremely well. He didn't have a harsh word to say about Justice Dorab Patel. There is a reason which Fali Nariman ascribes to this. Because Zia-ul Haq knew that if he lost power, if at all there is one judge who will have the independence and courage, it would be Justice Dorab Patel and nobody else whom he has appointed. With this, I would like to conclude my lecture, and I hope it has been of some interest to the students here. And I would like to once again thank the entire body of the university, Professor Suresh, Dr.
Yes.
Sati, and
Sir,
everybody.
fortunately, our Vice Chancellor, sir, has taken out time out of his busy schedule and joined us.
Yes.
He's an eminent academician and a very eminent administrator who has been serving this university for the last 40 years. And he has published almost 700 scholarly articles in various journals. He is a professor of computer science, basically, and he also has more than 10 books to his credit and many patents also. We are really fortunate to have such a dynamic Vice Chancellor who is also incidentally a law graduate, and he has a lot of passion for law, and he extends all his support for all our activities, sir. Sir,
Thank you.
is Sri Santosh Paulji, sir, Senior Advocate of Supreme Court of
Namaste, Mr.
Namaste, sir. Namaste, namaste.
Thank
Santosh
you
Paul.
very much for your scholarly and very informative lecture. In fact, you have explained us all the nuances of a very contentious issue pertaining to appointment of judges of the higher judiciary. Thank you very much, sir.
Thank you so much. Thank you for all of you.
Thank you. So with your permission, we can take up some questions, sir, and thereafter our Honorable Vice Chancellor, sir, will offer his remarks. Shall we do, sir?
Yes.
Sir?
Yes, sir.
Oh.
Thank you, sir. That was very informative and enlightening lecture. Now, with your permission, we can proceed to the question and answer segment. Yes, sir. The first question is as follows. Justice Kurian Joseph stated last year that he regretted his decision on NJAC by rejecting it. He stated that no improvements were made in current collegium system, also mentioning the establishment of a foolproof secretariat. What is your idea on this?
I'm partly in agreement with Justice Kurian. Justice Kurian was part of the 5 judges who decided NJAC, and he wrote striking down the NJAC and the 99th Amendment. I agree with him because during the arguments, it was said that you need to create a permanent secretariat. See, ultimately, how do you appoint judges? You will have to have somebody to read those judgments. It cannot be Mr. So-and-so say Santosh Paul is a great lawyer and he should be appointed. Somebody should see what is his body of work, whether he's meritorious, etc., etc. So this talk was there, but unfortunately, as Justice Kurian says, even today we do not have that secretariat. How do you decide a person comes from the High Court and he is to be brought to the Supreme Court? Somebody has to read the judgments. Unless that is done, you really don't know how this appointment is a meritorious appointment. I agree with him, but I would not agree with him to the extent that he feels that it should have been allowed, because that would have been the cure becoming worse than the disease, according to me. Of course, Justice Kurian is one of the most eminent judges, but I felt that NJAC was rightly decided. But if NJAC was rightly decided and if the intentions were absolutely to improve the system, one of the single most important things was to set up the secretariat, which has not happened till date. To that extent, I'm in agreement with him.
Thank you, sir. The next question is from Rajat M, wherein he asks, would it be better to have the process of referendum by a class of judges, inclusive of High Court, to further endorse the list of judges to be appointed, instead the power being only confined to 4 senior most judges, bestowed almost with monopoly while speaking for an entire organ of the judiciary, for its independence in its entirety, devoid of other voices in the same organ?
So as I understand your question, it is that instead of restricting it to a collegium of 5 judges, you say it should be, say, the 30 odd judges of the Supreme Court who should decide it. And I do not feel anything wrong in it. Only I feel whether it will be a workable solution, whether you will be able to bring in a kind of consensus amongst 30 people to appoint judges. It will be a task, but probably a mechanism perhaps can be evolved. But the chances of what I call a filibuster, that is, you do not allow a decision to be taken, is a possibility when the body becomes far larger.
So the next question is as follows. Can you suggest ways in which NJAC and collegium system can be balanced to benefit the judiciary?
As I said, the answer is partly given in your first question, which Justice Kurian said. You need to create a secretariat. You need to assess judgments of various judges who are in the bone of contention from the various high courts. Some kind of assessment has to be done independently by the collegium through the secretariat, and then come to the position that X or Y needs to be appointed. That is one way. And the other aspect is the difficulty, because we are such a large country. There are so many high courts. There are so many judgments. Even we as lawyers, we are not able to keep track of everything, or even a small fraction of it, because more or less areas of our interest today, thanks to a very interactive social media platforms like Live Law, etc., we are immediately alerted that a judgment has come on this point from this court and this and that. But it requires a far more meticulous work if you are going to say it will be an appointment on merit and merit alone. And that will be possibly achieved to a great extent on a permanent secretariat.
Thank you, sir. The next question is, sir, in despite of such struggle for autonomous, is theory of separation of power a myth as of in today's modern world?
As I said, the theory of separation of powers, does it really happen or does it not happen? Or to what degree does it happen? Or to what degree it does not happen? As I showed to you, like the US, I mean, it is virtually, if you control the court, you control the government, you control policies, you control what the Constitution means. And every question in the Constitution has a political aspect to it. So to say that there is a separation of powers, this judicial body is working independent and dehorse the political climate, is not exactly correct. But how do we achieve a balanced assessment of the Constitution, the rights conferred under it? How do we achieve it? How do we make the judges be independent out of dehorse the political system is a challenge. And as I said, one of the important breakthroughs here is the Judicial Appointments Commission of UK. Now, in UK, there is one more fundamental disqualification. One more fundamental disqualification is that if you are in any manner politically connected, so if a lawyer is politically connected, he is per se disqualified from judgeship. Now, there is I always cite the example of Justice V.R. Krishna Iyer. Krishna Iyer was the law minister in the world's first elected communist government, which came to power in Kerala. Now, in this system of the Judicial Appointments Commission of UK, Justice Krishna Iyer will not be appointed as a judge, given that criteria. So it is extremely difficult. And the other thing, which most of you law students would have been reading, what is called The Politics of Judiciary by Griffith, which is there in every law library nowadays, where he says, yes, you may be divorced from active politics, but you are still a political animal. You still have certain political views. You still have some views on society, how politics has to operate, what are the philosophies which will have to be applied, etc., etc. So to divorce the political component out of the judges is not easy, but political partisanship may be to a great extent eliminated if you follow the UK model.
So if you're willing, we can take one more last question.
Yes, yes, tell me.
Yes, sir. The last question is as follows. Could NJAC have passed within increased and strict measures, ensuring its transparency and accountability?
As again I said, the answer is partly given by Justice Kurian.
Okay.
How do you make it accountable? How do you make it transparent? How do you make it merit based? It is a serious challenge. And what Justice Kurian says is, yes, we have not been able to redress that so far. Even today, how does somebody become a judge of the Supreme Court? How does a lawyer get elevated to the High Court? What is it what are those objective criteria which you need to look into and which is assessed, which brings in a judge either at the High Court level or at the Supreme Court level? So this is a challenge which will continue. And as I explained it to you, ever since the Constituent Assembly debates, these concepts are under a state of flux. It is debated. There is no constancy on the theories. We have had theories. We had the primacy of the executive. It didn't work well. Then we have primacy of judges, which didn't work well either. That was sought to be alleviated by the NJAC, which they felt is a political component which is brought in. That is not allowed to work. So this debate is not an easy resolution. There is no easy resolution. The only thing is we will have to keep talking. We will have to see how to devise systems and try to work out some formulae. Otherwise, there is a big grievance amongst especially the junior bar. Now, when many of you will think, will I ever become a High Court judge? I do not belong to a law family. I do not belong to a premium chamber. Will I ever become a judge? No matter how meritorious I am. So these questions will continue to dog us. And there are no easy solutions. Every time we work out on something, there are some positive points and there are negative points. Especially the Skora judgment of 93. It worked well for a certain number of years, but then it became perceived that unless you belong to a judge's family, unless you belong to a judge's chamber or one of the elite is this, you cannot still become a judge. So these problems will keep coming up and we will have to find solutions to it. And the solution itself is not easy, even to reach us, even what do you call, theoretically a solution is not easy either.
Sir, now I request Dr. Satish Kaura, Senior Assistant Professor, University Law College, to ask his question to you, sir.
Yes.
Thank you, sir.
That will be a last question.
Yes, sir.
Thank you, sir. Thank you for your intellectual discourse. It was a wonderful lecture. I have an observation as well as questions with respect to appointment of judges of Supreme Court concern. Highly impartial, independent judiciary is very much required, not only to ensure fundamental right, but also to ensure federal democracy in a country like India. Actually, there was no issue up to 1973. In Keshavananda Bharati, when they invented the doctrine basic structure, Sikri somehow CJ retired, then instead of appointing any one among three, Justice Goyal, Shalat and Hegde, they appointed A.N. Ray. The issue started there itself. Then again in 1975, when Jagamohan Sinha in Allahabad High Court declared Indira Gandhi's election unconstitutional, again, when they transferred the judges from one state to another state, again the issue was raised. In fact, I read in one of the chapter written by Vaneville Astin, where he mentioned judiciary under pressure. Then in 1977, one more case, that is after ADM Jabalpur versus Shivkant Shukla, because one dissent judgment by Justice H.R. Khanna, I think what you have mentioned, Dorab Patel in Pakistan Supreme Court, in the same way, Justice H.R. Khanna also acted, where in the case of ADM Jabalpur, because of his dissent judgment, he was not appointed as a CJ, M.H. Beg was appointed. Then after that, Justice P.N. Bhagavati, whoever rendered judgment in favor of the then government, all enjoyed CJ position. Because in ADM Jabalpur versus Shivkant Shukla, Justice A.N. Ray was a CJ, then M.H. Beg becomes CJ, then Y.V. Chandrachud becomes CJ, then P.N. Bhagavati also became CJ. And even in fact, he confessed the mistake committed in the case of IIM Jabalpur case. Now the issue, after that you told about president primacy, executive primacy, CJ primacy, and collegium primacy, then NJSC. Now the issues are, we have three type of judges can be appointed for Supreme Court. Number one, maximum from bench, and few from bar, like Santosh and Malhotra madam, whoever is now. Only a few, I think, even it has not crossed more than 10, I think. Then no one from distinguished jurist. Fine. So when such being the case, I have what is your opinion about the recommendation made by MNV? Because in 2002, same NDA government constituted a committee, Constitution Review Committee headed by MNV. MNV suggested for two type of commission. Number one,
MN Venkatchalaya.
MN
Venkatchalaya.
Wonderful recommendation. I felt it, but what is your? I don't know what is your opinion and all. Where he suggested in first case, in first committee, there are 6 people. One will be the CJ, who is the chairman, and 4 will be the senior most judges of Supreme Court. 1 will be the law minister. At the same time, otherwise, another commission is suggested, including 2 eminent persons. Now, whatever it may be, judges will have a primacy to decide the appointment of judges. I think, in my opinion, if the same NDA government in 2014 also, if they had implemented the recommendation made by MNV, I think judiciary wouldn't have come forward to declare this NJSC unconstitutional, number one. Number two, my opinion, since the maximum judges are appointed to Supreme Court from bench, that is from High Court, why can't we concentrate on finding some important eligibility criteria to appoint judges of High Court? In my opinion, I read some of the book written by Subhash Kashyap, where he wrote a book on citizen and judiciary, where I have read so many articles written by Justice Verma, then Justice Prashant Bhushan, Shanti Bhushan. Many judges have given their own opinion, where I came to know, why can't we All India judicial examination, like UPSC, how we conduct? In the sense, not seniority should also be considered. While filling application to become judge of High Court of respective state, let them impose condition like 10 years practice, and at least he should have minimum percentage in LLB, and he should have, because an advocate who has not practiced constitution, who completely practiced in criminal court and all, he becomes judges of High Court, then he will be elevated as a judge of Supreme Court. Then even he sits in the constitution bench. When such being the case, why can't we have specialization even in the judges? And even if we just go for making some provision, in the sense eligibility criteria, finding out some eligibility criteria to even to get eligibility to appear to write examination in, like UPSC, All India Judicial Examination. This one is fine, or would you suggest to go for the recommendation made by MNV?
See, as I understand it, your question, I will divide it into 2 parts.
Yes, sir.
One is to have a exam. When it comes to appointment of judges, you want an exam. That is one aspect.
Yes.
The second aspect which you're suggesting is that, listen, somebody who, see, ultimately these people reach the Supreme Court, so he should know constitutional law. Now, I'll just, on both counts, I will just answer that as quickly as I can. See, as far as written exam is concerned, see, there is a certain reason why judges in England were elevated from the bar. There's a certain reason to it. Vis-a-vis promotions from the lower judiciary. Because a person from the bar who has practiced as a lawyer, the horse, any position being held in the lower judiciary, the advantage, and I'll tell you, when it comes to practice, he is far more bolder when it comes to writing a judgment against the government. See, when it comes to a personal liberty, they are far more bolder than judges who have been promoted. I mean, I'm telling this with a lot of thought which has gone into it, and that is why the elevation from the bar is a very important and an integral this to the appointment of judges. Because in law, especially in constitutional law, it is the liberty of the individual versus the state. And if you have somebody who has been serving the state through and through, he will be more reluctant to write a judgment against the government, be it personal liberty, be it a high-handed action of the government authorities, etc. But a person elevated from the bar will be more likely, which is why UK, it is very important that the persons who are appointed are dominantly from the bar. In fact, I'll give you an illustration. You see, Thomas Paine was one of the great philosophers of Europe, and he inspired the American Constitution. Thomas Paine, The Rights of Man, and he wrote a piece sitting in England. He denounced the monarchy in England, and said he was charged with treason, and he was brought before. I mean, he ran away to France. That's a different matter. But he was tried in absentia. And the man who stood up for him was a very eminent barrister called Thomas Erskine. And Thomas Erskine was, all kinds of threats were effected on him, that he should not be defending a man who has spoken against the monarchy. But Thomas Erskine, and I'll tell you, Mr. Satish Gowda, I'll send it to you. He has a very important opening speech when he defends Thomas. He says, the day a lawyer is told that he should or should not appear for a particular person, the liberties of England are dead. So that spirit of the bar, so to eliminate the bar, and you say you write an exam, and all, many practitioners, to be very honest, will not be able to write an exam and will not have the time nor the inclination. So you will eliminate a set of people who may not be great lawyers, who will be not having much time to work on the field, but will have enough time to write exams.
Yeah. Even many eminent advocates, with your kind permission, sir, even when it is offered also, they will deny it.
That is also there. The other aspect which you talk about, the second component, see, ultimately all these matters, it is, as I told you, it's a very difficult thing to judge. It's very difficult to judge. And we have seen, now I've spent about 31 years, people who are not great lawyers became great judges. It's not that the most eminent lawyer becomes the greatest judge. H.R. Khanna came, and even this theory that the bar, you are more independent. H.R. Khanna came from the district court. He was not directly elevated to the high court. Yeah. But yet, he became one of the greatest judges of this country. So there is no uniform criteria. Now look at Justice Krishna Iyer. He was a political person. He had certain strong political views. Yet, he's one of the foremost judges of this country has ever produced. So it becomes very, very difficult. As I said, in today's standards, Justice Krishna Iyer will not become a judge. He was the law minister. He was the home minister of under Nambudiri Party's government. So there's the question of him becoming a judge. So it becomes very, very difficult. As Justice Kehar put it, during the argument in NJS, he put it something like this. You see, for your daughter, you will try to get the best man as a husband. You will search high and low and everything. Yet there may be a mistake. So he kind of brought that. So it is extremely difficult to assess, but as you say, there has to be some ground norms. There has to be some ground norms, and we'll have to keep evolving.
Yes, sir. Thank you, sir.
Thank you, sir. Thank you very much. So now I request our Honorable Vice Chancellor, sir, to kindly give his remarks. Yes.
Okay. Thank you very much for inviting me to this last
pleasure,
part
sir.
of the lecture, but I think I'm not that eminent, or I do not have that type of expertise to talk on National Judicial Appointment Commission. But I can say just only say that Articles 124, 217, and 222 at the time of Indira Gandhi had played a very important role. And it is probably from 1973, they found that NJAC has to come into picture. That is because earlier to that, as Professor Santosh Pal, I'm saying because he's so eminent, and before that, there was an example given by Santosh Pal, like we are Krishna here. Then, in fact, today's norm does not permit NJ Krishna, we are Krishna here to become a judge. But when I saw about the question about Satish Gowda saying that an examination is conducted, if you ask any professor to take an examination in any university, he will not be able to take up. And in fact, he will not pass the examination. Because that at that age, when they're 50, 55, the capacity to remember and then to write judgments and all in the examination mode will be very difficult. It is the experience which counts at that point of time. It is his past which counts. Why does a person gets appointed promoted from associate professor to professor? We don't ask him questions, basic questions. We'll ask him what he has done, how many papers he has written, how many books he has written. So in the similar manner, we'll ask, when a person tries to become a judge, we'll find out whatever his judgment, what type of judgments he gave, the past, whatever he has, contributed to the body of judiciary knowledge. That is what we have to look into. Now, when we spoke about Dorab Patel, it is very difficult for anybody to become independent in this society. In one or the other way, we try to have a relationship. We say it is our relative. We say he is our community. He says he is our political leanings. All this comes into picture. Now, the question is whether NJAC or collegium, which is better? In the ideal system, collegium is better if everybody is good. But now you see that that also consists of different shades of judges, different types and different affinities. And that's why now they have started criticizing collegium, because we are not able to appoint impartially. But then the executive wants its pie. Apple, we want the pie from the apple, and therefore they say we should also participate in the spoils. Yes. If you are able to appoint a judge, why should we not be able to appoint a judge? Then because you are also committing mistake, let us also commit some mistake and make it much more colorful. So the difference between now the collegium and the NJAC is that who will be getting an upper hand. So when we see this discourse or this debate going on, we are finding whether it is the collegium which has to be improved or whether it is NJAC which has to come into picture. So, but there is no one correct solution for this. It is only thing is that if everybody becomes honest, both NJAC or collegium will be good.
Both are good.
We can both can be applied. But absolutely, when that happen, unless we are honest, unless we are sincere in approach, both the system is deteriorating. Both the system will not do good. But one thing I can say, it is always better to have a collegium and a sincere set. Maybe instead of 6 judges or 30 is too large a system, and 6 is too small a system, because we are taking first 5 judges. Why don't we say that instead of taking first 6 judges, take some people in the 30 and make the body little bigger and see that you come out with better this thing. And also, in order to support this, 6 or 10 people, there must be a secretariat. We must be able to make elaborate notes of all the people who are going to be appointed or transferred. So when that comes, when transparency comes into picture, whether it is NJAC or collegium, we will be fine with it. Okay. And that's what I would like to say. And thank you very much for giving me a chance to just talk about it. And I am very grateful to the Department of Law, saying always they invite me to this lecture discourses in law. And, I feel very happy because I have taught computer science for 41 years. I just, studied law for 3 years. And still I would like to participate. And today, whatever I was listening to Santosh Pal's, discourse, and even the questions asked answered by the students, and a body of erudite scholars who have been attending this. I feel illuminated. I mean, I want to acquire knowledge, and that's why I always make it a point to come to such type of lectures. Thank you one and all, and thank the Suresh Nadagowda for inviting me, Dasharath and Sudesh, and we know 3 more teachers are there, senior teachers, senior Professor Satish Gowda, Jyotish Vishwanath, and Chandrakanti. And thank you, Santosh Palji, for being present with Bangalore University Law College. And it is a wonderful lecture. Thank you one and all.
So thank you very much, sir, for your very candid and useful remarks and gracing the program and blessing us. Thank you, sir.
Thank you.
Thank you, sir. It is always interesting to hear you speak as you continue to inspire and guide us all. Thank you, sir.
Yeah. So
now I take this opportunity to announce the next guest lecture in the ULC special lecture series. We will be having with us Shri Satish Manishande, Senior Advocate, High Court of Mumbai, who is an eminent criminal practitioner who has handled various important cases, including the case of famous actor Sanjay Dutt, who will be delving on the topic Review of Preventive Detention Laws in India on 27th October, Friday at 5 p.m. So do tune in for the next lecture as well.
okay.
As we come to the end of today's session, I extend my heartfelt gratitude to all the dignitaries for gracing this occasion. Now I request Dr. Satish Gowda and Senior Assistant Professor, University Law College, Bangalore University, to propose a formal oath of thanks. Over to you, sir.
Thank you, Arshita. Good evening to all distinguished dignitaries, guests, members of faculty, students, and participants present in this lecture series on critical analysis of National Judicial Appointment Commission Judgment 2015. I'm really honored to propose the vote of thanks. In fact, today we have with us Sri Santosh Paul, Senior Advocate, Supreme Court of India. Sir, in fact, who made time out of his busy schedule to grace this occasion. On behalf of Bangalore City Law College, I extend my sincere gratitude to Santosh Paul, sir, Senior Advocate, Supreme Court of India, for gracing the occasion with his erudite presence. Sir very eloquently spoke about the all important cases, right from S.B. Gupta versus Union of India, Judges case number 1, then Judges case number 2, Supreme Court on record Advocate Association versus Union of India, then in Presidential Bill, Supreme Court Judges case number 3, then last one, Supreme Court on record Advocate Association versus Union of India, that is Judges case number 4. And sir, in fact, spoke about even UK and US system and all. It was really informative and thought-provoking lecture, sir. Our interaction with you has been an enriching learning experience. Thank you, sir, for illuminating our minds in the course of our interaction with you today. And again, once again, I express my heartfelt thanks to you, sir, on behalf of Bangalore City and on behalf of our Vice Chancellor, sir. Thank you, sir.
Thank you, Santosh Paulji.
Thank you, Mr. Venugopal. Thank you, Mr. Suresh.
And Bangalore University is blessed to have Honorable Vice Chancellor, Professor K.R. Venugopal, sir, who is well-known academician and researcher. His relentless effort and proactive measures introduced in the University Law College have brought tremendous changes in the university. We are highly indebted to our beloved Vice Chancellor for his constant support and guidance for all our endeavors. Sir, I express my sincere thanks for gracing the occasion.
Thank you, one and all.
Thank you very much.
I also thank our beloved principal, Professor Dr. Suresh V. Nadagowda, sir, and our chairman and dean, Professor Dr. N. Dashra, sir, our senior professor, former principal, dean, Professor V. Suresh, sir, for their constant effort and constant encouragement and support to organize this wonderful, meaningful event of this special lecture series, sir. I also thank our faculty members, Dr. Jyoti Vishwanath, Dr. L. Chandrakanti, and all guest faculty members, and especially our law students from research department and post-graduation department and undergraduate department. Thanks to all the dignitaries, deans of different departments, chairmen, faculty members, professionals, students, media for your active participation in this special lecture series. Thank you, one and all.
So thank you, sir. Thank you very much. And it's my special request to Paul, sir, kindly make a visit to our institution soon after this pandemic gets over. And we'll be honored to have you with us and have a physical interaction with you along with our students. Thank you.
Most certainly. In fact, my first decision was
Yeah.
to actually set up practice in Bangalore.
Yeah,
It
great.
never happened. That was my wish, which did not happen. But certainly, this will be one of my wishes is to come to your university.
Yeah,
Please,
please,
sir.
please.
So sure.
Hearty welcome.
Meet
Thank
the
you.
Vice Chancellor and all of you.
Yeah. Thank you, sir. Thank you very much.
Thank you so
Thank you,
much.
sir. Thank you. Namaste.
Thank you, sir. And with this, we conclude today's session. And I would want to thank University Law College and Department of Studies in Law for giving me this opportunity to host this session. Thank you, one and all. Have a pleasant evening.
Thank you.